After studying this chapter, you should be able to explain how constitutional, statutory, case, and administrative laws are created, explain how to resolve conflicts between constitutional, statutory, case, and administrative laws, and describe the differences between criminal and civil, substantive and procedural, and business and other forms of law. Laws in this country are created at all three levels of government: federal, state, and local. The laws at each level consist mainly of constitutions, statutes, administrative regulations, and case law. A constitution is a document that sets forth the framework of a government and its relationship to the people it governs. When constitutions are adopted or amended, or when courts interpret constitutions, case law is made. You are governed by both the Constitution of the United States and the Constitution of your state. The Supreme Court of the United States is the final interpreter of the federal Constitution. The Connecticut Supreme Court is the final authority of the state constitution. Federal and state constitutions are concerned primarily with defining and allocating certain powers in our society. Constitutions allocate powers between the people and their governments, between state governments and the federal government, and among the branches of government. The federal Constitution is the main instrument for allocating powers between people and their government. It does this with the first 10 amendments, called the Bill of Rights. The Bill of Rights protects people from actions of their government. The federal Constitution also allocates powers between the federal and state governments. The Constitution gives the federal government the power to regulate both foreign and interstate commerce. Interstate commerce occurs between two or more states. The power to regulate intrastate commerce, which occurs within one state, is left with that state. Constitutions allocate power to create a system of checks and balances among the three branches of government: the executive, legislative, and judicial. This ensures that no branch of government becomes too powerful. The federal Constitution created the Congress of the United States. State constitutions created the state legislature. Acting for their citizens, these legislatures enact laws called statutes. All states delegate some legislative authority to local governments. Thus, towns, cities, and counties can legislate on matters over which the state has given them authority. Such legislation is created by a town or city council or by a county board or commission. Legislation at the local level usually is called an ordinance. Federal, state, and local legislatures all create administrative agencies. Administrative agencies are governmental bodies formed to carry out particular laws. The Federal Social Security Administration, Connecticut Department of Environmental Protection, or the Haddam or Killingworth zoning commissions are examples of administrative agencies. Legislative power means the agency is authorized to create administrative laws, also called rules and regulations. The Federal Social Security Administration might establish rules for determining when a student is a dependent or a widow or widower and qualify to receive Social Security payments. The Social Security Administration might, for example, hold a hearing that decides whether a particular student is in fact a dependent. The judicial branch of governments creates case law. Case law usually is made after a trial has ended and one of the parties has appealed the result to a higher court. This appeal will be based on legal rulings made by the lower court in deciding the case. When the appellate court publishes its opinion on a case, that opinion may state new rules to be used in deciding the case and others like it. This process creates case law. Similarly, each state creates case law through its state courts. The effectiveness of case law arises out of the doctrine of stare decisis. This is Latin for to adhere to decided cases. This doctrine requires that lower courts must follow established case law in deciding similar cases. The doctrine of stare decisis generally does not bind Supreme Courts. Generally, however, case law doctrines are carefully established and seldom revoked. Constitutions are the highest source of law, and the federal Constitution is the supreme law of the land. This means that any federal, state, or local law is not valid if it conflicts with the federal Constitution. Similarly, within each state, the state constitution is supreme to other state laws. When a law is invalid because it conflicts with the Constitution, it is said to be unconstitutional. The appropriate Supreme Court determines when law is unconstitutional. Statutes or ordinances must be constitutional to be valid. Ordinances must not exceed the powers delegated to local governments by the state. The courts may invalidate a rule or regulation if it is outside the scope of powers delegated to the agency by the legislature that created it. Courts are not the final authority on the effect of statutes. A legislative body has the power to nullify a court's interpretation of a statute or ordinance by abolishing or rewriting it. Administrative agencies also can revise their regulations when challenged. Common types of laws are civil laws, criminal laws, procedural laws, substantive laws, and business law. When the private legal rights of an individual are violated, the matter is governed by civil law. Civil law refers to the group of laws that redress wrongs against individual persons. Civil law applies when one person has a right to sue another person. The police do not take action in civil conflicts. If a defendant loses a civil case, that defendant is liable. A crime is an offense against society. The offense is governed by criminal law. Acting in the name of all the people, the government investigates an alleged wrongdoing. If a crime is committed and the person responsible can be found, the government will prosecute. Conviction of a crime can result in a fine, imprisonment, and in some states, execution. Usually, when a crime occurs, private rights of the victim are violated also. A violation may be both a crime and a civil offense. The victim of the crime may sue the wrongdoer. Procedural law deals with methods of enforcing legal rights and duties. Laws that specify how and when police can make arrests and what methods can be used in a trial are procedural laws. Procedural laws determine whether equitable remedies, such as injunction, are available. The doctrine of stare decisis is a procedural law. There are two types of procedural law: civil procedure and criminal procedure. Criminal procedure defines the process of enforcing the law when someone is charged with a crime. Civil procedure is used when a civil law has been violated. Civil law is concerned only with private offenses, and police and public prosecutors generally do not involve themselves in civil offenses. Substantive law defines rights and duties. It is concerned with all rules of conduct except those involved in enforcement. Substantive law defines offenses such as murder, theft, vehicular homicide, breach of contract, and negligence. Business law covers rules that apply to business situations and transactions. Business law is important for all students, not just those planning careers in business or law. Most business transactions involve a merchant or a consumer. Business law is largely concerned with civil law, primarily contracts. Torts are private wrongs or civil offenses against people or organizations. Torts are distinct from breach of contract. For example, torts may occur when manufacturers make defective products that injure users. The Uniform Commercial Code, or the UCC, is a widely adopted uniform business law. It covers such areas as sales of goods, certain aspects of banking, and lease of goods. In summary, federal and state constitutions set the framework of government and its people. State and federal legislatures, acting for their citizens, write and enact laws known as statutes. Administrative agencies are government bodies formed to create and carry out particular laws known as rules and regulations. The U.S. Supreme Court is the final interpreter of the federal Constitution. When constitutions are adopted or amended, or when courts interpret constitutions, case law is made. Statutes or ordinances must be constitutional to be valid. Ordinances must not exceed the powers delegated to local governments by the states. The courts may invalidate a rule or regulation if it is outside the scope of powers delegated to the agency, the legislature that created it. A legislative body has the power to nullify a court's interpretation of a statute or ordinance by abolishing or rewriting it. Administrative agencies also can revise their regulations when challenged. Civil law is applied when an individual's private legal rights have been violated. It is applied whenever one person has a right to sue another person. The police do not take action in civil conflicts. The court may compel an individual to pay damages or to refrain from doing something, such as an injunction. An offense against society is a crime and is governed by criminal law. Conviction of a crime can result in a fine, imprisonment, and in some states, execution. Procedural law deals with methods of enforcing legal rights and duties and ensures fair practice and consistency in the due process. Procedural laws specify how arrests can be made and the rules or procedures to follow in trials. The doctrine of stare decisis is a procedural law. There are two types of procedural law: civil procedure and criminal procedure. Substantive law defines rights and duties. It is concerned with all rules of conduct except those involved in enforcement. Substantive law defines offenses such as murder, theft, breach of contract, and negligence. And business law covers rules that apply to business situations and transaction. It is largely concerned with civil law, especially contracts.